Thank you, everyone, for coming out tonight. My name is Jeff Pochinowski. I'm an associate professor of law at the Notre Dame Law School. I'm here to introduce John Finnis. A common rhetorical device for people in my position is to start by stating the speaker needs no introduction. In this case, such a statement is actually true. Professor John M. Finnis needs no introduction, but he deserves a good one, and I'm honored to try my best. I've been told that when strangers ask Professor Finnis who he is, he describes himself as an Australian constitutional lawyer. In a sense, that is true, just as it is true in a sense that Australia is an island in the Southwest Pacific, and that Sydney is a town with a harbor. John, I was considering using Adelaide as a town with some parks, but I'm not sure it would have translated as well. Since completing his doctorate in law at Oxford as a Rhodes Scholar, Professor Finnis has taught at places as varied as Adelaide University, University of California, Berkeley, Boston College, and the University of Malawi, whose football team I hear is slightly better than BC's this year. He is best known, however, as a chaired professor at Oxford, and to our great fortune here at Notre Dame since 1995. He's also a fellow of the British Academy, and has served on the Catholic Bishops' Joint Committee on Bioethical Issues, the International Theological Commission, the Pontifical Council for Justice and Peace, and the Pontifical Academy Pro Vita. He's been a governor of the Linacre Center for Health Ethics, advised the Foreign Affairs Committee of the House of Lords, and has worked in government in Australia on matters of constitutional federalism. The breadth and depth of his work in law and jurisprudence is simply astounding. This Australian constitutional lawyer, however, writes prodigiously and incisively in moral philosophy, ethics, political theory, the philosophy of action, theology, history, and literature. In 2011, Oxford University Press issued a second edition of Professor Finnis's path-breaking book, Natural Law and Natural Rights, along with 5 volumes of his collected essays. I estimate that those 6 volumes combined represent less than half of his life's work. A 2010 bibliography of his writing spans 12 single-spaced pages and consists of 211 individual works, as various as Skepticism, Self-Refutation, and the Good of Truth, and an essay on Shakespeare's intercession for love's martyr. Professor Finnis's work does not sacrifice quality for quantity, however. In the area of Professor Finnis's scholarship with which I am best acquainted, jurisprudence, one can say that John Finnis is the legal philosopher writing today most likely to be read by scholars 100 years from now. And that has been said, including by people who have greater philosophic training and less philosophic sympathy than yours truly. The paper Professor Finnis revisits tonight, The Priority of Persons, exemplifies the analytic rigor and the basic soundness of his jurisprudence. Building on the classical tradition of Aristotle and Aquinas, Professor Finnis underscores a foundational point often ignored in current legal thought, that we can only grasp law's nature by understanding its basic purpose of promoting the flourishing and common good of actual living, breathing, embodied, and dare we say, ensouled persons. Failure to do so, Professor Finnis argues, blinkers legal philosophy and leads the legal system away from justice. The world knows him as one of its greatest living legal philosophers. We at Notre Dame are blessed to also know him as our Biochini Family Professor of Law. Without further ado, I present you Professor John M. Finnis.
Thank you very much, Jeff, for that most generous introduction and for stopping your précis of the essay I'm going to revisit tonight, having captured its essence but not fully set out its properties. That was an essay I wrote for a book of Oxford essays in jurisprudence published in the millennial year. And now, 12 years later, Carter Sneed thought I could revisit it without inducing too much indigestion after this nice dinner and the very rich menu of debates and discourse that he put together for our nourishment these past 2 days and nights. So I'll do that, and I reassure you that we will soon leave the law and lawyers behind. What I'll be adding, by way of thoughts that have occurred to me in this decade, is not all uniformly mellow. The priority of the 2000 essays title was first the priority of status and importance. Persons are the most important part of law's concern and law's nature. And was second, the priority in the title, the priority of the past as preceding the present. This latter chronological priority, in turn, has more than one aspect. Roman legal thought, even in its pre-Christian classical forms, and certainly in its definitive semi-codified form settled by Christian jurists under the Emperor Justinian in the early 6th century, in the same remarkable decade in which Benedict settled his monastic rule and the Church at the Council of Orange settled its doctrine of grace, Roman legal thought was superior to most present-day legal theory, superior by its explicit recognition that persons are the point of law. And there is again the fact that careful consideration of what it is that makes law and rules of law is the past acts of persons who acted legislatively or judicially to lay down law, by acts which referred forward to the future, which includes our present, and the future in which we can deploy the rules resulting from those acts to mould a better, fairer future for ourselves or our successors in the future. Talking about the existence of rules, an existence that philosophers of law find challenging to explain, is in fact talking about a relationship between persons, some in the past, some in the future to be benefited, and some, us in the present, considering how to decide by keeping faith with the relevant past persons and having care for the relevant future persons. The essay showed in detail how the refusal by the 20th century's greatest legal theorist, Hans Kelsen, refusal to allow persons any place in his legal theory save as the subjects of legal duties, encouraged New York's Court of Appeal 6 months before Roe against Wade, in a judgment silently quoted in part by Justice Blackmun in Roe, to hold that whether human beings of a certain sort are in law persons is a mere matter of policy, quite outside the competence of courts and legal reasoning. That judgment was in Byrne against the New York City Health and Hospitals, and Byrne was a Fordham law professor who was doing what he could in advance to stop the abortion juggernaut that was soon to sweep away everything, even New York's shoddy new law, in Roe's maelstrom of historical falsifications, broken-backed logic, and blatant special pleading. In my essay, I coupled both the Byrne judgment and the Roe judgment with Dred Scott and Sandford, or versus Sandford. All three are cases where the judges professed themselves helpless in the face of a just, law-based argument by or on behalf of real human beings. These judges asserted in each case that the law's own theory of persons and legal personality, of who counts as a person, prevented those arguments about unjust and unlawful treatment from having any purchase in judicial reasoning. The court in Dred Scott was persuaded, or professed to be persuaded, by what they called the attitude of the founders, that black Africans can never be constitutionally made United States citizens. The court in Byrne was professedly persuaded by Kelsen and the court in Roe professedly by the inapplicability to the unborn of some of the 14th Amendment's references to persons, persuaded that the unborn cannot be constitutional persons even though corporations are, by judicial fiat, despite the inapplicability to corporations of some of the 14th Amendment's references to persons. In each of these cases, the court should have thought, like the Romans, that law is for the sake of persons, and therefore, before all legislation and even constitutional provisions, we and our courts ought to have a realistic and just account of what persons are and who are persons, and ought then to interpret legal and constitutional provisions so as to align them, as far as possible, with that just and realistic juridical, juristic, legal account and principle. After all, the world community, reflecting on the disaster of the Nazi years, came up in 1948 with a universal declaration of human rights that silently quotes the Roman lawyers saying at the beginning of Justinian's Digest that by nature all human beings are born free, meaning free and equal in dignity and rights. That saying comes only a few sentences away from the definition of justice itself, the firm and lasting willingness to give to all others their right or rights. Here the all others is quite open-ended and implicitly extends naturally to all human beings. Well, interpretation of the sort that ought to have occurred in Dred Scott and Byrne and Roe and Planned Parenthood and Casey is a matter of basic openness to justice and to those who are by nature entitled to equal justice. Interpretation of another sort is a matter of understanding not so much words or a language as people who are using or did in the past use words in statements meant by them to convey a meaning, a proposition that they wanted to convey. It is a matter of understanding persons in one of the very most personal of activities, intending and communicating. And the essay concluded in these terms. What then are the natural facts which should inform juristic thought about the persons whom law exists to serve? What is this human nature which in its bodiliness is known to lawyers as injured in crimes and torts, and sustained by the resources always somehow disposed of in property rights, howsoever artificial, and which in its irreducible intellectuality is known to us as the maker of signs, signatures and meanings and subjective intentions? Well, here jurisprudential reflection can helpfully go back to its origins, perhaps in Plato's reflections on the trial and execution of Socrates. The essay went on, in the act of, say, speaking to my partner in discourse, perhaps the court I am addressing as advocate, or the client I am advising as a jurisconsult, I understand my utterance as the carrying out of a choice which I made, and in the same act I am aware of my audible uttering. I see the hearers register their comprehension. I feel, say, confidence or anxiety. I remember a past misunderstanding, and I hope my statement will make my point. This experience and understanding of the unity, including continuity, of my being as a feeling, willing, observing, remembering, understanding, physically active and effective mover or cause of physical effects, and equally simultaneously an undergoer and recipient of such effects, all this is a datum which philosophical exploration of human and other natural realities can account for adequately only with great difficulty and many a pitfall. Still, prior to all accounts of it, this intelligible presence of my many-faceted acting self to myself is a datum of understanding. One and the same I, this human being, who am understanding and choosing and carrying out my choice and sensing and so forth, as I described, is a reality I already truly understand, albeit not yet fully, explanatorily, with elaboration. Indeed, it is only given this primary understanding of one's understanding, willing, and so forth, that one can and typically does value such understanding, freedom, voluntariness, unity of being, and so forth. So, as Aristotle and more clearly Aquinas argue more or less explicitly, any account proposing to explain these realities must be consistent with the complex data it seeks to explain. Data which include the proposer's performance, outward and inward, in proposing it. It will not do to propose, as many today propose, an account of personhood such that spirit person and mere living body are other and other. For spirit person and mere living body are philosophical constructs, neither of which refers to the unified self, the person who had set out to explain his or her own reality. Both of those constructs purport to refer to realities which are other than the unified self, yet somehow inexplicably related to it. And on the last page of the essay I said, the only account which meets the condition of consistency with the explainer's own reality and performances will be an account along the lines argued for by Aristotle and Aquinas. The very form and lifelong actuality by which the matter of my bodily makeup is constituted the unified and active subject, me, myself, that is a factor, that form and actuality is a factor, a reality which Aristotle, after Plato, calls psyche and Aquinas calls soul, or anima. And in the human animal, the very same animal whose interests in every individual case are to be taken equally into account, from the very outset of his or her existence as human, it is this one essentially unchanging factor, unique to each individual, which explains, first, the unity and complexity of the individual's activities, second, the dynamic unity in complexity, in one dimension, the program of the individual's growth as embryo, fetus, neonate, infant, and adult. Thirdly, the relatively mature individual's understanding of universal, for example, generic immaterial objects of thought, for example, classes of entities, or truth or falsity of propositions, or soundness and unsoundness in reasoning. And fourthly, this unique individual's generic unity with every other member of the species. In members of our species, the one factor unifying and activating the living reality of each individual is at once vegetative, animal, sentient and self-locomotive, and intellectual, understanding and self-understanding, and even in thinking, self-determining by judging and choosing. Of course, the manifold activations of these bodily and rational powers are variously dependent upon the physical maturity and health of the individual, but the essence and powers of the soul seem to be given to each individual complete, as wholly undeveloped radical capacities at the outset of his or her existence as such. And this is the root of the dignity we all have as human beings. Without it, claims of equality of right would be untenable in face of the many ways in which people are unequal. This metaphysics of the activity of discourse, advocacy, adjudication, lecturing, and writing enables jurisprudence to stabilize its most fundamental concepts, the good, which, because it's the good of members of a group who are all persons, can and should be a common good, and the rights, which justice essentially consists in respecting and promoting unyieldingly. Well, those were the essay's final words, so I've revisited the essay. Those words mentioned membership of a group because the essay had one other topic which I have scarcely mentioned to you. I did mention a moment ago that the Supreme Court in the 1880s extended 14th Amendment protection to corporations, holding them to be persons and refusing to explain, even in a single sentence, why they should be so regarded. The essay glanced at an old chestnut, the favorite law school topic. In what ways are corporations legal persons, subjects of legal rights, deemed to enjoy legal personality, a phrase that hovers between the two historic sources of the word person, persona as mask, to which corresponds the law's carefree attribution of legal personality to anything that figures as subject or topic of legal relations, say 44 barrels of rum at New York's harbourside, or an idol in a temple in old British India, and on the other hand, persona as individual substance of a rational nature, as Boethius defined it early in that same most fruitful decade that closed with Justinian's corpus of Roman law. But that academic lawyer's topic is in truth less interesting, I suggested, than the question alive in the more open fields and horizons of social theory. Are groups real? Do they act? Or only their members? The essay's answer was, a human group or community has all the reality of group action, as well as of the group's members, the human person's acts and dispositions to act, dispositions which are manifested in the members' readiness to participate in and emotional responsiveness to the group's action, for the sake of the good or goods which gives point to that action. That's to say, the reality of a group is the reality of an order of human, truly personal acts, an order brought into being and maintained by the choices and dispositions to choose and responsiveness to choices of persons. A group's act is defined by the form in which it is proposed to members of the group for them to participate in or not, as they choose. Social acts, though irreducible to the acts of persons in the people in the acting group, are constituted exclusively by those acts, acts of individual human persons. So, those in bare outline were some salient elements in my thought about persons a baker's dozen years ago. And without subtracting any of those, I would like to add now another 6 themes or theses or thoughts. First, then, I soon realized that I had been too easygoing in alluding to the position of the United States Supreme Court. So in the essay on natural law theory for the Oxford Handbook of Legal Philosophy in 2002, an essay which in my collected essays I grandly call the Grand Tour of Legal Theory, I said, since law and legal thought are entitled to little respect or consideration unless they serve or can be brought to serve every person whom they could benefit, all the basic human rights should be regarded as controlling every otherwise open question of interpretation. The basic error of the United States Supreme Court in Dred Scott versus Sandford was to approach the interpretation of the Constitution's provision, for example, in relation to the congressional power of naturalization, without a strong presumption that, whatever the assumptions and expectations of its makers, every constitutional provision must, if possible, be understood as consistent with such basic human rights as to recognition as a legal person. An essentially identical error is made by those judges, such as Justice Scalia, who interpret the 14th Amendment's unelaborated references to persons as permitting state legislatures or electorates to treat as non-persons and to authorize the killing or the enslavement in embryo banks of the unborn, whom these same judges know to be in reality human persons. My close colleague Jerry Bradley has a very illuminating essay in a forthcoming book of essays that Robert George and John Keown are bringing out with Oxford University Press in March next year under the title Reason, Morality and Law. Professor Bradley's essay shows how the law as it has developed in most states of the United States, in healthy and commendable reaction to Roe, denies equal protection of the law to those persons who are convicted of offences of homicide or child destruction committed against an unborn child by way of conduct that is substantially identical to the kind of conduct by mothers and their agents that Roe and Casey declare to be incapable of being made a crime when done by them. Now, in some cases, these mothers would be entitled to the legal and, I think, moral justification of their conduct as self-defense against a threat of death or very serious bodily harm. But Roe and Casey hold that they need never even plead such a justification. That is, that their conduct in aborting and killing the unborn child cannot be subjected to any requirement that it be justified or defended at all in legal proceedings. It seems to me that these justices, who recognize the constitutional doctrinal falsity of Roe and Casey, can no longer treat the issue as one of states' rights, but must in reason recognize the 14th Amendment's requirement that no state deny to any person within its jurisdiction the equal protection of the laws, as a requirement the content of which is determined by the truth about persons. I do not suggest that making this argument would or will be the easiest task an advocate, jurist, or justice could face, but it is doable. Think 1868. If told that the proposed 14th Amendment would have the constitutional effect of protecting not only former slaves and their descendants, but also unborn children, there is scant reason to judge that the requisite majorities for ratification in 1866 would have fallen away. In that year, the Supreme Court of Iowa declared that, and I quote, "The common law is distinguished and is to be commended for its all-embracing and salutary solicitude for the sacredness of human life and the personal safety of every human being. This protecting paternal care not only extends to persons actually born, but for some purposes to infants in ventris a mère, in the womb. The common law stands as a general guardian holding its aegis to protect the life of all." And on less originalist criteria of constitutional interpretation and development, the amendment's phrase, "any person," should be taken and should have been taken as including the unborn child, for the purposes of those and only those protections relevant to and reasonable in light of the child's condition, on a footing of fair equality and no more than that of right to life with its mother. All the more so, a fortiori, by criteria of interpretation sufficiently accommodating to make possible the attribution of unheard of, unarticulated constitutional rights in Griswold versus Connecticut, Eisenstadt versus Baird, and Lawrence versus Texas, not to mention Roe versus Wade itself, and many other less dubious developments of constitutional doctrine. The legitimate interpretative development in relation to any person should have occurred, I think, as soon as the issue was squarely raised. Robert Byrne of Fordham Law School raised it squarely enough pretty much as soon as New York began to lead the nation towards a relaxed abortion law. But he was brushed aside with bad Kelsenian legal theory that no legal theorist now gives the time of day to, and with Justice Blackmun's contemptuously and contemptibly lazy hand-waving in Roe. Jerry Bradley's new discussion shows how the law is now squarely at odds with itself. Having broken free from the old categories such as inducing a miscarriage or terminating pregnancy, typical state laws, regularly upheld in the courts, look, despite Roe, to destruction of the life of the unborn child. The conservative justices' willingness to turn a blind eye to all this cannot, I think, reasonably be sustained. The liberal justices, of course, are interested, as they make no secret, only in the result, not at all in reasons, if these block or even delay or discourage the result. And that brings me to my second additional theme. The secular liberalism that entirely dominates the modern state, most politicians in both parties, the educational system in all its state or public and most of its private forms, and almost the entire mainstream media, that secular liberalism is strongly reminiscent of the two-truths theory, often called Latin Averroism, that Thomas Aquinas hurried back to Paris in 1268 to combat, and did combat with zeal and efficacy. There in the university, leading professors were teaching or insinuating that there can be two truths, the propositions taught by Catholic faith and the contrary propositions taught and proved by philosophy, in particular the cutting-edge philosophy of the newly rediscovered Aristotle as they interpreted him. George Orwell's indispensable word, doublethink, captures this sort of teaching as the intellectual corruption and blindness to reality that it is. The modern equivalent is much more widely taught. There is nothing real but matter, nothing of real fundamental order but chance, nothing free in choosing, and nothing really good but what I freely choose. Yet people truly are entitled to the real good of autonomy and equality of rights. But we can see through this web of falsehood and doublethink by noticing even the simplest of our signs or pointers. Say, to take Elizabeth Anscombe's example, the act of pointing to some figure to distinguish its shape from its colour, and perhaps to go on to compare, analogize the figure's shape with Bunker Hill on Old Boston Harbour, and the colour with the red coats struggling up the hill. Or take again the act of attending to the pointer's pointing, to understand the precise point being made by the pointing about the figure, and then perhaps about the comparison or analogy. Both pointing and attending are intentional acts whose intended objects are spiritual in two ways. They are, first, intelligibilities, shape and colour as concepts, and as elements in analogies, and as what the person pointing intended and meant. And secondly, they are the communicating of these to an audience. Even so simple an exemplary situation then gives us a way of grasping the kind of radically transmaterial spiritual objects of human action, and thus a way of grasping human capacities, and thus of understanding something of what it is to have a human and personal nature. Acts of meaning, say pointing, or poetic composition, or rigorous scientific reflection, or of struggling to translate an after-dinner speaker's accent, like other intentional acts, say resolving to act fairly, or betraying, or promising, or rescuing, are understood by those who choose to do them, and by intelligent participants and observers, as actions of an individual, a responsible person, author of and answerable for his or her conduct. Even when they are successful deceptions, though in that case in an extended sense, they express the person, someone whose complete, non-fungible distinctness from other human persons the human baby begins to be aware of, and soon enough to understand, as the baby locks onto and follows eyes and begins to learn to read them, that is, to make inferences from them as if they were windows of the soul. Intentionality, emotionality, sensitivity of the person whose eyes they are. To that person, his or her own individuality, responsibility, authorship, and subsisting identity are vastly more transparent. At the same time, the fact that other persons have the same kind of, and therefore thoroughly particular, non-replicably individual, transparent to self and partially self-shaped identity, the same kind of identity, that's as indubitable as if it were transparent rather than inferred. Despite their difference, each of these logically distinct kinds of knowledge of the person fits easily within our idea of the experienced and perceived. Together, these ways of knowing oneself and others as not only intelligible but also intelligent, not only active but each a doer and maker, these provide the stable, factual basis for the practical standards of reasonableness in action, standards centering on do to others as you would wish them to do to you, and don't do to them, and so forth. Such norms or principles, being about what is needed to instantiate the good of being reasonable and the good of friendship, are not inferred from their factual foundation. Rather, they take those facts as the matrix, so to speak, for the practical insight that they articulate. The insight that a way of relating personally and humanely to other persons is not only factually possible, that's a fact, but also new insight, desirable, intelligent, and in itself incalculably superior to alternative ways of relating, such as sadistic harm-doing or indifference to the baby lying abandoned in the snow alongside my path. So those principles, being about what is needed to instantiate the good of being reasonable and so forth, that fact about them turns out to mean their being about what is needed to be a person who respects other persons for their own sake and sees the need to give to each of them their due, and indeed to, in ways involving all manner of prioritization and nothing merely sentimental, love, will the good of, love these neighbours as oneself. These goods are not mere abstractions, still less the sort of willful fictions or projections that secularist relativism and doublethink claims they are. They are states of affairs such as my coming to understand something that had puzzled me and knowing something of which I was ignorant. The benefit of being informed rather than ignorant, healthy rather than ill or disabled, alive rather than dead, living in friendship rather than hatred. In every case, one understands these goods as good for me and anyone like me. The at first indefinite extensional and intentional reference of anyone like me is clarified in reflection as any human person. For reflection on the continuity of one's own identity and life through sleep, through traumatic unconsciousness, through the unrememberable eventfulness of one's infant life, through one's life in the womb, and, as it may be, one's future life in senility and dementia, Shakespeare's second childishness, such reflection makes evident that what is valuable for oneself is valuable and significant in a qualitatively similar way for any being with the same kind of capacities as oneself. For all of us, those dynamic capacities were once only radical capacities, and then by maturation and good health became active capacities ready for immediate actualization in actions made intelligible by their objects, mostly intended objects of the kinds I recalled just now in exemplary form. So it is the sharing in radical dynamic capacities that is the basic unity of the human race or species, and by virtue of the true goodness and directiveness of the basic human goods, is the ground and foundation of the human rights, which are specific objects of that directiveness in its interpersonal implications. What is fundamentally good and bad for me is fundamentally good and bad for you. One's identity as a person with interests that are truly intelligible goods, all the way back to one's beginning as a pre-implantation embryo, with the radical capacities whose ultimate objects, those same intelligible goods, one now participates in and deliberately intends, that identity is the ontological foundation of one's human rights, because it is the foundation of one's judgment that I matter, and of one's duties to respect and promote one's own good, and therefore of one's judgment that others matter, and of one's duties to other persons to respect and promote their good, the duties we call the content of justice. For they too, those persons, similarly, have such identities all the way back and all the way forward to the end of their lifetimes, such radical capacities and intelligible forms of flourishing and harm of just the same kind as one's own. Just as immaturity and impairment do not in one's own existence extinguish the radical capacities dynamically oriented towards self-development and healing, so they do not in the lives of other human persons. And there, as the old essay said, is the ontological unity of the human race and the radical equality of human persons, which, taken with the truths about basic human goods, grounds the duties whose correlatives are human rights. Duties to or responsibilities for persons. Justice. Where these duties are negative duties of respect, duties not to intentionally damage or destroy persons in basic aspects of their flourishing, they can be unconditional and exceptionless, absolute rights. Where they are affirmative responsibilities to promote well-being, they must inevitably be conditional, relative, defeasible, and prioritized by rational criteria of responsibility such as parenthood, promise, interdependence, compensation and restitution, and so forth. Such criteria of priority and responsibility, in combination with other conditions of securing common good, are in play in shaping the reasonable specification of the obligations of membership in one or other of the communities, political and non-political, of which one is non-voluntarily or voluntarily a member. And many such obligations are correlative to rights. Thus, for example, the obligation of parents to their children are correlative to rights of those children to support, nurture, education, protection, and so forth. Rights which in their basic aspects, at least, can reasonably be called human rights. And on gross parental default, such obligations pass to surrogates specified by or under law, against whom the rights avail thereafter. And I'll say a word more about such obligations in a few minutes. Understood as grounded in the truths about human makeup and well-being that I've been recalling, human rights and the justice of respecting them are vindicated against general moral skepticism, against the scientific materialist, or in Alistair McIntyre's phrase, secular naturalist, scientific naturalist, half of secular liberal doublethink, and are vindicated against the charge of speciesism. For they are predicated of all human persons, not as members of the class, our race, our species, nor out of an emotional or arbitrary sympathy of like with like, but as beings, each and all of whom have the dignity of having the at least radical capacity of participating in the human goods that are picked out in practical reasons, first principles, first and foremost the good of human existence or life, and that makes sense of all human intending. For dignity, once again, denotes a rank of being. A rank of being. And all beings of this rank have the worth that we reasonably predicate of beings and ways of being that participate, even if only radically, in those intelligible goods, participate in them, even the bodily and earthly goods, in the remarkable way that I earlier called spiritual. And so when flourishing maturely, participate in them intentionally and with intent that others of the same rank share such participation and flourishing. And the each and all in those preceding sentences demarcate the sense in which we all are basically equal and entitled to the concern and respect appropriate to human persons and to the substantive human rights applicable to our state of maturity, health, and activated capacities. Differences of innate intelligence and aptitude that are properly relevant to the distribution of educational opportunities, say, amongst one's own children, and of occupational responsibilities, are differences quite irrelevant to this dignity of the human over all that is subhuman, and to the human rights to equal concern and respect, life, and so forth. Well, I want now to focus on an aspect of the realities of personhood and the truths about justice that is often underplayed or overlooked. Time, continuity, the past that this moment will so soon belong to, as will the minutes still in the future of this talk and our conference and our own lives. The past, the now, and the future, all spoken of in the verses from the Epistle to the Hebrew that we heard tonight at Mass. And this aspect will give me my third, fourth, fifth, and sixth additional themes. One's direct, unmediated, non-inferential knowledge of oneself is of what one experiences as happening to one corporeally, which includes psychologically, and of what one is doing or actively inclined to do, whether spontaneously or compulsively, or by one's free choices. One knows oneself as a being extended in time, who can decide to respond to a question with reflective search for an answer, discover what seems to be the answer, communicate it to the questioner, and when it has been communicated, know that the question was given a relevant answer. Know that I who heard the question also found and gave an answer, and know whether it is or is not the same answer as I gave or would have given when I first came across a question of that content in another age 55 years ago. Time and the passing of human existence in time is a necessary condition for all my opportunities of commitment and achievement, all the perils of deflating failure, discredit and humiliation, and the truth and dignity of gratitude. The experience of all this is made possible, of course, only by memory, prime witness and testimony to one's personal identity. But we should not be impressed by thought experiments such as those that tempted John Locke and his followers to take memory, consciousness of the past, to be not merely a witness and testimony to one's subsisting, lasting personal identity, but to take them as its very reality, that in which that identity, my identity, consists. Such an account of one's subsisting identity as one and the same human being would defy our most elementary knowledge of ourselves and others as beings who subsist and who can and must acknowledge our authorship of our own acts, notwithstanding decay or even loss of memories. As a preliminary to my reflections about the relevance of time, let me just say a word about the term social justice. This term was introduced into the magisterial teaching of the Catholic Church in Pius XI's encyclical Quadragesimo Anno in 1931, having entered French, Italian, and English discourse in the half-century after 1830, with something like its elusive modern secular meaning. The use of the phrase in the encyclical gives us a main part, at least, of its useful meaning. Pius XI says that, I quote, "The law of social justice is that the common good of all society be kept inviolate." And the encyclical articulates this principle in the context of the institution of property. That institution, it says, is for a purpose, the common good or advantage of all, and not every distribution of private property rights is compatible with that purpose. Claims that the sole just title to ownership is labour are as contrary to social justice as claims by the wealthy to retain all the fruits of their ownership without distributing any of it to workers. Again, according to the encyclical, social justice, I'm quoting, demands that changes be introduced as soon as possible whereby every adult working man will be assured of a wage large enough to meet ordinary family needs adequately, unquote. For it is an intolerable abuse to be abolished at all costs, the encyclical says, that mothers are forced on account of the father's low wage to engage in gainful employment outside the home to the neglect of their proper cares and responsibilities, especially the upbringing of children, unquote. More generally, social justice demands that wages be, I quote, so managed by agreement of plans and wills that they are set neither too high, thereby causing unemployment and consequent social disorder, nor too low to provide adequate means of livelihood measured by the needs of a family. And looking at the economic system as a whole, the encyclical says that social justice calls for control of monopolies and cartels that displace free competition, a competition which itself needs to be kept within certain limits by public authority. Capital, the class of owners, violates social justice and the common good and the dignity of workers when it controls the non-owning working class and the whole economic system to its own will and advantage rather than the common good. Now, what is common to these uses of the term social justice is that they concern not, or not directly and primarily, the distribution of some common stock, but rather the impact and side effects of relationships which are, at least primarily, between private individuals or entities, such as relationships of employment or of spouses and children. We need a concept of social justice to supplement the Aristotelian categories of distributive and corrective or compensatory or, more broadly, commutative justice, because we cannot adequately gauge the requirements of justice without asking how some distribution or measure of compensation or some imposition or recognition of duties of care or performance is likely to affect the common good of one's society. And that common good cannot reasonably be assessed without full attention to one's society's extension through time. The time of its past in which undertakings and contributions were made, wages were earned, crimes and negligence were committed and suffered, children were conceived, commitments were entered into, and so forth. Of course, and this is my fourth addition, some kinds of injustice are done and can be understood without reference to the past. To take a couple of obvious examples, there is the horrible injustice done to those children who are generated as a result of permitting same-sex couples or trios or quartets or other pluralities to participate in the social institution dedicated essentially to procreation and upbringing of children, marriage. For same-sex unions can never procreate, but they can, and not rarely will, pay for the generation of children who have some father, some egg donor mother, some gestation mother, and after birth some adoptive father who may or may not be feigning the role of mother, or some adoptive mother who may or may not be feigning the role of father, each for a child who in any event is planned and doomed from the outset never to be brought up by his or her actual mother and father, which is what marriage is most fundamentally about. This severe injustice is a particularly deplorable extension of the injustice intrinsic to every generation of a human child, conceptus or embryo, by IVF. A choice that, precisely as a choice, always reduces the child at the time of its conception to the status of a product, and thus to a fundamental subordination to its makers, a radical inequality manifested by the all but universal practice of submitting all such embryos to scrutiny to decide whether they shall live or shall be consigned to death, because in some way defective or of the wrong sex or other characteristics, or simply because surplus to current requirements or needed as an organ bank. And this is only one of the injustices involved in or ineluctably accompanying same-sex marriage. Those of us who dream that our own genuine marriages will not be affected by same-sex marriage will be rudely awakened when our children come home from school aged 5 or 6, having been subjected to the first stages of a decade-long program of social conditioning designed to gender mainstream them, that is, to impose on them the ideology, the equality-based ideology, according to which there is no naturally or intrinsically reasonable and normative sex, male or female, or role, mother or father, but rather an ever more finely variegated spectrum of so-called gender identities, to be discerned, or rather adopted, after agonies of pseudo-discernment and choice, lesbian, gay, straight, bisexual, transgender, intersex, queer, and so on, all the way, in due course, I believe, to paedophilia and bestiality. This dreadful abuse of children will cause many more suicides and or suicidally reckless lifestyles that might be avoided by retaining as morally relevant the biological truth that in all but a freakishly tiny number of unfortunate mutants, every one of us is male or female and can live reasonably, and in the last analysis can only live reasonably, as a boy or a girl, a man or a woman. The assault on social justice entailed by legally concocted same-sex marriage goes further. One of its most important elements, which I cannot elaborate tonight but have done so elsewhere, is the defiling and obscuring of the idea of the marital act in the consciousness of the children, the defiling and obscuring in the consciousness of the children that I've just mentioned, and of everyone who approves of same-sex marriage as an option for some persons. For approval of the pseudo-marital sex acts of same-sex couples, or approval of any of the many kinds of non-marital sex act, whether same-sex or otherwise, entails a kind of conditional willingness to engage in sexual activity in a way that is in truth non-marital. That is, in a way that does not allow the parties to the act to thereby actualize, express, and experience their marriage as a committed, permanent, exclusive friendship open to procreation. And such willingness, while it endures, is incompatible with genuinely marital acts, and thus wounds the marriage of those couples, one or both of whom has such a willingness, however remote and conditional. And such a wound is not only an injustice to the other spouse, and to the children impaired by consequently limping or failed marriages, and to those injured by those children, it is also contrary to social justice in the additional and fundamental respect that it makes vanishingly unlikely the sustainability, long or even medium term, of the societies, the peoples that have wounded their institution of marriage by encouraging and endorsing such false and harmful ideas. The wounding of marriage to bring it into line with the contraceptive, abortifacient, feminist, and other marriage-dissolving demands and practices of many heterosexuals has already put our societies on an ever-steepening path to extinction, a downward path only concealed in the United States and some other countries by the country's willingness to allow other peoples to enter lawfully or unlawfully to replace, and in a good many instances with a pretty explicit purpose of replacing the now indigenous people. A willingness that in the European and British cases does not even succeed in masking the population trend towards disappearance. Since social justice, like the social charity that Pius XI couples with it, is about actions and dispositions that affect other people in ways respectful of or promotive of the common good of a definite body of people, the wounding of marriage is a real, true, and grave violation of social justice. Which brings me back to violations of justice that presuppose the lastingness of persons, their duration, their past, and its continuity with their present and futures. And I want to finish by reflecting on two kinds of injustice within this very broad range, where the priority, the preeminence and fundamental significance of persons, each person, takes on the other chronological sense of priority, where we acknowledge what is owed to persons because of what happened in their past. And before we get to the promises made by them and to them in the past, or the work they did, the contributions they made, the degrees or grades they earned, or the crimes and torts they committed, each of us has two fundamental facts about us: one's family and one's nation, my fifth and sixth additional themes. In his very last personal work, meaningfully entitled Memory and Identity, composed in the 1990s in his prime and appearing within 2 weeks of his death in 2005, Karol Wojtyła, Pope John Paul II, wrote, "The term nation designates a community based in a given territory and distinguished from other nations by its culture. Catholic social doctrine holds that the family and the nation are both natural societies, not the product of mere convention. Therefore," and he italicizes this sentence, "therefore in human history they cannot be replaced by anything else." Unquote. "The right way of avoiding unhealthy nationalism is," he wrote, on the same sort of page, "through patriotism. Whereas," and I'm quoting, "nationalism involves recognizing and pursuing the good of one's own nation alone without regard to the rights of others, patriotism is a love of one's own native land that accords rights to all other nations equal to those claimed for one's own." Unquote. And, again quoting, The native land or fatherland, patria, is in some ways to be identified with patrimony, that is, the totality of goods bequeathed to us by our forefathers. In this context, he goes on, one frequently hears the expression motherland. Through personal experience, we all know to what extent the transmission of our spiritual patrimony takes place through our mothers. Our native land is thus our heritage, and it is also the whole patrimony derived from that heritage, the land, the territory, but more importantly, the values and the spiritual content that go to make up the culture of a given nation. Unquote. From those statements, we can look backwards to the Second Vatican Council, which in its document on the Church's universal mission, ad gentes, sent to the peoples or nations, teaches, Christians belong to the nation, ad gentem, in which they were born. They have begun to share in its cultural treasures by means of their education. They are joined in its life by manifold social ties. They feel its problems as their very own. They must give expression to Christian newness of life in the social and cultural framework of their own homeland, patriae, according to the traditions of their own nation, nationis, a culture which they should get to know, heal, preserve, develop in accordance with contemporary conditions, and finally, perfect in Christ. Section 21. Or we can look forwards to Benedict XVI addressing in September 2008 the bishops of France, a state whose nation and culture are strained and even slowly withering by reason of its indigenous ex-Catholic population's unwillingness to reproduce itself and a reckless immigration policy promoted and in its extent and contours concealed by its political and religious elites such as the bishops. Benedict XVI said to them, I am convinced that nations must never allow what gives them their particular identity to disappear. The fact that different members of the same family have the same father and mother does not mean that they are undifferentiated subjects. They are actually persons with their own individuality. The same is true for countries, which must take care to preserve and develop their particular culture without ever allowing it to be absorbed by others or swamped in a dull uniformity. And then he quotes, in the next sentence, his quotation from John Paul II, the nation is in fact, to take up the words of John Paul II, the great community of men who are united by various ties, but above all precisely by culture. In the same address to UNESCO in 1980, from which Pope Benedict was quoting, his predecessor had spoken of the right of the nation to the foundation of its culture and its future, of a stable element of human experience and of the humanistic perspective of man's development, namely, a fundamental sovereignty of society which is manifested in the culture of the nation, through which, at the same time, man, and he means each individual person, is supremely sovereign. Unquote. What might that individual personal sovereignty or autonomy mean, such that it is enjoyed through a fundamental sovereignty of that same individual person's nation and its culture? One may get a first indication of its meaning and its truth by reflection that your freedom to listen to and debate or reject my talk this evening presupposes a shared language, a shared fund of knowledge of the kinds of things that I have mentioned and that I am presupposing you know, not to mention the vast stock of material culture manifested in our surroundings and in the whole way of life and course of education that brought us all here, in every case by sovereign individual choice. All this belongs to what John Paul II called the vast patrimony, the totality of goods bequeathed to us by our forebears. And what might be the manifold social ties and various ties besides culture that give a nation its reality and enable its service to human and personal well-being? In his book, significantly entitled The Law of Peoples, John Rawls, like John Paul II and John Stuart Mill, takes shared culture to be central to the reality of a particular people and analyzes this cultural reality into, first, and primarily, the members of this people being united among themselves by common sympathies, which do not exist between them and others, which, b, make them cooperate with each other more willingly than with other people, and c, may result from various causes, such as commonality of race, descent, language, and religion, but, quote, strongest of all is identity of political antecedents, of national history, and consequent community of recollections, collective pride and humiliation, pleasure and regret, connected with the same incidents in the past, unquote. And then Rawls articulates the legitimate fundamental interests of peoples, his word for nations, their political independence and their free culture, the security, territory, and well-being of their citizens, and, quote, their proper self-respect of themselves as a people, resting on their common awareness of their trials during their history and of their culture with its accomplishments. These popes and philosophers are drawing on their and our knowledge of history and of the formation of their own and our own mentalities and character to reach conclusions which show up as the 1/3 truth, 2/3 falsehood that it is, the now common saying, once unheard of in political thought, that diversity is strength. And be that as it may, these conclusions provide a foundation for thinking responsibly about the question, in at least some respects, the most important question of justice today, whether the undoubted right of individuals and families to emigrate carries with it a right of individuals and families to migrate and demand entry to and the right to remain permanently in a country of their choice, say yours. In circumstances such as the present, where there is no dire necessity or none that could not be relieved by our provision of aid to be used in the country concerned, is it the case that those who make up, say, the 1.2 billion people of India have the moral right, as a matter of justice, to migrate to the United States, or 1 million a year of them, and the people of Pakistan and Bangladesh, as numerous as the present population of the United States, or 1 million a year of them, too, and 1 million from Indonesia, and so on. The Catechism of the Catholic Church states, without citing any precedent for it, that, and I quote 2241, the more prosperous nations are obliged, to the extent they are able, to welcome the foreigner in search of the security and the means of livelihood which he cannot find in his country of origin. Political authorities, for the sake of the common good for which they are responsible, may make the exercise of the right to immigrate subject to various juridical conditions, especially with regard to immigrants' duties towards their country of adoption. Immigrants are obliged to respect with gratitude the material and spiritual heritage of the country that receives them, to obey its laws and to assist in carrying civic burdens, unquote from the Catechism. Views corresponding to a wooden interpretation of to the extent they are able, prosperous nations are obliged to the extent they are able to welcome the foreigner and so forth. Such views corresponding to a wooden interpretation are often presented, even at very high levels, as if the phrase meant that, subject to those legal conditions about criminality and payment of taxes and so forth, you are required as a matter of justice and rights to admit foreigners at their choice until perhaps the wealth and internal security of your country is degraded to the level at which there would no longer be an incentive to immigrate. But the phrase, to the extent they are able, needs interpretation, just as much as the sentence just 6 sentences earlier in the Catechism, those subject to authority should regard those in authority as representatives of God, who has made them stewards of his gifts, unquote. Properly interpreted, this is not, in truth, a directive to treat Hitler or Stalin or Chavez or Khomeini as representatives of God. And prosperous countries have a duty to receive foreigners just to the extent that that is compatible with justice. And those foreigners are and remain genuinely willing to respect with gratitude the spiritual heritage of the country, as faithful adherents of at least one, if not several, of the major religions of India, say, are very probably not. In assessing the justice of immigration, the political authorities, a term which at election time includes all voters, are obliged to use the law of social justice. The common good including not only those goods of culture that the Pope today warns can be swamped and lost, but also the goods threatened by the real prospect of injustice, by neglect of all the obligations of justice that have been incurred to those indigenous, that is, non-immigrant citizens, who have contributed to the prosperity or security, that is, the peace and law-abiding order of the country, and who in many cases may be thrust into more or less permanent unemployment by a constant flow of immigrants, or, if not, may, in many more instances, be burdened with much higher taxes and much reduced pensions or other welfare provisions, and much inferior educational facilities for their children and grandchildren, not to mention the threat of injustice to all who, generation after generation, may suffer grievously or subtly from the violence, unfairness, and lack of civic friendship that are sometimes characteristic of multicultural and multi-ethnic communities, such as the Yugoslavia that after 70 years disintegrated with grievous, bloody brutality, destruction, and expropriation into 6 separate countries 20 years ago. There's no need and no opportunity here tonight for a sufficiently detailed analysis of this kind of injustice or of the consequently intricate issues of justice involved in these great questions of immigration and multiculturalism. These are questions often pronounced upon with a carelessness and lack of frankness far removed from the care with which Leo XIII, acknowledging as we all must the truth that all the non-personal resources of the world are morally available and for the benefit of all human persons, yet firmly and plainly vindicated the rights and justice within wide limits of acquiring and holding private property and receiving rents and profits, something he did in face of widespread calls for socialist or communist redistribution and levelling or conversion to claims upon the welfare distributions of a state universal owner-manager presumed to be the representative of divine providence. Calls which at first glance might be, and by many well-meaning people have been, regarded as implications of Christian charity and the love that transcends justice. North Korea, founded and long ruled by the son of Christian activist parents, is a monument, extreme, of course, to such one-dimensional thinking. Communism about property is not so popular as it once was amongst the secular wealthy elites to which we belong. Its close analogue, favour for a cosmopolitan transnational vision of open borders, is so taken for granted in these elites that documents from the ecclesiastical bureaucracies, whose members belong to these elites, need a careful and reflective scrutiny that they still too rarely receive. And I hope at least to have stimulated some such scrutiny just a little. And let me end by saying something sixthly about the related second kind of injustice arising from neglect of the temporal dimension of our life as persons, in families, nations, and humankind as a whole. Let me start again with John Paul II's words. The family and the nation are both natural societies, not the product of mere convention. Therefore, in human history, they cannot be replaced by anything else. In the works of political liberals such as Rawls and Dworkin and Rouse and Habermas, the family makes little or no appearance. Yet real political order begins only when the menace to it of unduly dominant familial loyalties is overcome by the proper relationship of mutual respect and support between families and nation. And the dream of an autonomously self-created self must be judged another one-third or quarter truth in face of the reality that what I have is so substantially what my parents chose for me in cultural and moral formation that even if I choose to follow another call by, say, conversion to the gospel of Christ and his church, I substantially still am, through and through, the beneficiary of and shaped by my parents and the national culture to which they belong. And I can scarcely do more than hope to heal in myself and a few others that culture which willy-nilly is part of my identity. Nor is the family merely a category needed for a sound political theory and social teaching. It is the living reality of father and mother, children and grandchildren and perhaps great-grandchildren, linked not only by genetics and language and beliefs and skills, but also by what John Paul II's encyclical in Evangelium Vitae called the covenant between generations. Justice cannot be respected unless this covenant is honoured in all its mutuality, parents and grandparents honouring it by love and service for the children and grandchildren, who in turn honour it by rejecting Daniel Callahan's seductive call, so characteristic of alienated or half-alienated Catholics, and such music to the ears of the state's healthcare bureaucrats: time's up. You've had your turn, your innings, your 70 years and 20, or is it 10? Time to stop draining the families and the nation's wealth. In the wintry decades ahead of us, assisted suicide and euthanasia, adopted in the name of autonomy and relief from suffering, will become also means to shuffling off the expensive elderly of a people who have for 2 generations chosen to deform the truth of marriage and the marital act, and to wave away the ideal of the mother as educated, cultivated queen, in Pius XI's word, of a household of sons and daughters, and so have chosen to make themselves deficient in children and thus in grandchildren and aunts and uncles and nieces and nephews, and are almost incredibly choosing or allowing themselves to become no longer a self-determining people or the ruling culture in their own land. On this course of developments, a covenant between the generations will soon be, for many, their only access to justice and to a personal care that is given by prayer and example as well as taken. For many others, that access will only be a might have been, since they, and I fear we, chose not to honour or preserve for them its preconditions. Thank you.
I think we have time for a few questions. Okay.
Thank you, Professor Finnis. I'm Father Ed Andreco. I'm a Franciscan, and I just make a very simple plea that we might examine the thought of the metaphysician, theologian John Duns Scotus on justice, his affectio justitiae, affectio commodi, in dealing with these issues. I think there are ways of drawing that out and bringing it into the public forum. And then the second plea would be
What's your translation of his Latin?
the affectio justitiae, the affection for justice, and the affectio commodi, the affection for the commodum, the common good. What is good? What is for our happiness, or what serves me, or what serves others? But the justitiae is the highest. That's the highest level of charity, as I understand it. And then the second would be Our Lady. Here we are at Our Lady's University, and if we could examine her role as the memory, you used that magnificently in the talk, as the memory of the church. She is the one who brings to us to remember all of these factors that we can't lose. We're losing them little by little. You're very, very clear in showing where we're sliding into a certain nihilism. But she is the memory of the church that can bring this back. All that you hold so beautifully, which I think every one of us holds with you. So thank you.
Thank you. Yes. Well, Our Lady is the memory, but she is in heaven, and our access, we can pray to her. Our access to the memory of what God has revealed as His promise, as His offer of adoption into the divine family, is something that we know of through the Church and its book, the book that it adopted and defined, the Bible, as read in the Church and as communicated to us in the Word and sacraments. So, yes.
Yes.
Jerry?
Professor Finnis, you spoke of the case of IVF and described these multi-party pregnancies that are the fashion these days. And you described further the child which results from generation of this sort as a product, that was an injustice to the child to be brought to be as a product. And I wonder if you might just say a little bit more about the sense of that term, or why or how we should call this child a product, because metaphysically, of course, that child is the same reality as any other child born. And of course, you rightly mentioned how the parents all too often judge the worthiness of this fetus to see whether it's measuring up to some plan for them. Now, that makes the child a kind of product, but I'm not sure if we should say that that attitude reflects something else about the status or position of this individual, or whether that's part of what it means when you say it's a product.
Yes, the clarification that you're wanting is one that I'm more than happy to attempt to make. I signified it rapidly in the sentence that I articulated that proposition in, by saying that in the act of choice to generate a child through the means of others, technicians, interventions with the gametes that are provided, whether within marriage or from outside marriage is much more common, but even in the sort of purest case of husband and wife, altogether detached from the marital act, in such a choice, the child, though in truth, for all the reasons that I mentioned, it is an equal of us all, from the moment of its conception, in that act, the child is conceived as, in the specification of the proposal, a product. It's specified as a product to be brought into being by these makers, these technicians operating at the time of their choosing and so forth. And thus it is put at that very moment into a position of radical inequality, such as is, as it were, ontologically involved in the very relationship of maker to product. Now, the parents may resolve, and have resolved right from the outset, to treat the child nonetheless from the very moment of conception as a child and not as a product. But they can't escape the implication of the nature of their conduct. The child comes into being not as a gift supervening on their mutual act, but as the product of a making with materials that they supplied, biological materials. And of course, such a resolution is in fact extremely rare. Most parents are willing for the technicians to survey the products and choose only the fittest and so forth, and consign the others to any of the fates that I mentioned.
Doug Castle?
Thank you, John, for a very thoughtful and intense presentation. I have two related questions. One of them is methodological. The methodological question, and I'll situate it in the context of your views on gay marriage and raising of children by gays. The methodological question is whether empirical data, one way or the other, would affect any of your analysis at all. For example, suppose that one were able to show, and I have no idea what the data show, that a significant percentage of children raised by gay couples consider themselves to have been raised by a loving couple and thrive and prosper in every sense of education and success in life, as much or more than children raised by traditional marital families. Suppose there were a whole set of data like that, and data furthermore that showed that the parents of those children, the gay parents of those children, to use that phrase, were as happy or happier than parents, and lots of data like that. Would any of that make any difference at all to your analysis, or is your analysis based entirely on your conception of what is natural and right, independently of any empirical data? And again, I have no idea what the empirical data would show. I'm not sure it even exists. Secondly, and related to that, to what extent was the, I forget your exact words, but it was a severe injustice that you say is inflicted upon children raised by a gay couple. To what extent do you believe that that is equally true of a gay couple that is not married, so we're not bringing into question the institution of marriage, but rather is simply together in some civil or de facto union? Thank you.
Yeah, well, to take the second one first, obviously the situation of children in the family of an unmarried couple is at least as bad and probably much worse than, or significantly worse, but anyway, at least as bad as that of the same couple who've been certified by the state as married. So my complaint is not about gay marriage, except to the extent that it is a kind of social ratification and approval of a kind of relationship which ought not to be ratified and approved. So you see that the injustice is just as great, if not greater, in the case of uncommitted or unmarried same-sex parents as if they have made the commitment certified by the state as either civil partnership or marriage. For these purposes, the injustice to children is substantially the same. What's particularly undesirable about the state certifying this as a marriage is that it positively encourages, in the way that the ideas of civil partnership itself doesn't, the generation of children. The state is certifying this couple and their relationship as one that actually has the status of the institution which is about children, which is for the sake of children. So I think there is an additional attack on the common good in the state certifying the relationship as not only a recognized civil partnership, but as a marital partnership. Now, in order to acquire the data that you envisaged, which certainly doesn't exist at the present and could not exist for a couple of generations, 60 or 70 years, one would have to approve the subjection of children to this kind of experiment. Now, of course, the experiment is underway, but its being underway is precisely the sort of injustice that I'm complaining of. I believe we can identify this as an injustice independently of data that doesn't yet exist, and so we can judge that this is not something that ought to be put in place in order to be experimented upon and for the sake of acquiring data or for any other reason. And I indicated some of the reasons for that in the idea of deliberately conceiving, generating a child with the intent that it shall never have as its actual parents the ones who are its parents, and there might be two, or there might, for the reasons I mentioned, be three or even four. I think we can say straight off the bat, just as we can say in relation to other kinds of acts like torture, that they are an injustice that people ought never to be subjected to, independently of experimentation over history, to see whether, looking at all the consequences of people being subjected to torture and people not being subjected to torture, the information that was gained and the false information, and all that adds up to a better state of affairs or not. And similarly with other kinds of acts. Paedophilia, do we want to subject a generation of children to the experiment of acquiring data, which a lot of paedophiles would like us to have the opportunity of gaining? Do we want to do it by empirical data? No. And so, there's nothing suspicious or dubiously metaphysical or a priori or rationalist about making the same sort of judgment for the same sort of reasons in the case of this radical distortion of marriage on which the good of society and all its members so fundamentally depends. Now, the judgment that it so fundamentally depends is one that has been, as it were, experimentally verified over thousands of years. And so we're in good shape to make that kind of initial judgment. And we can look at the forms in which familial and as it were, marital, there's a spectrum of marriages, polygamy, polygyny, and so forth. So we can look at the kinds of societies that develop in polygamous circumstances. We could look at the kinds of societies that develop in the situation of genuine marriage where there's true commitment and it's not open-ended, and compare that with the kinds of societies that have the other forms, and including the modern contemporary last 50 or 60 years of serial polygamy, open-ended marriage, less obligatory on its partners than any other form of contract and so forth. The results are in or coming in, and they're not impressive in their ratification of the choices that were made to introduce that kind of marriage for the sake of heterosexuals 50 or 40 or 30 years ago.
Well, I've been given the signal that we have unfortunately run out of time. Sorry for questions that have gone unasked. Thank you.
My apology for
No.
taking the time.
No.
Yep.
Well, I'll hand this over to Carter now.
Well, thank you all. That concludes the 13th Annual Fall Conference of the Center for Ethics and Culture. I'd like to thank all of our speakers, once again, all of our moderators, the staff, most especially Stephen Fredoso for all of his work, Angela Pfister, Tracy Westlake, our wonderful students, Margaret Kennedy, Angela Bermudez, Aaron Stoyal Mulholland, Kate Everett, and Liz Everett, our fellows of the Center for Ethics and Culture, our senior distinguished fellow, John Finnis, Peg Brinig, our Remick fellow, Ryan Madison, our Miser fellow, and thanks to all of you for coming and making this a very special event. And please join us next year, November 7th through 9th, for another installation, the 14th Annual Fall Conference of the Center for Ethics and Culture. Have a wonderful evening and travel safely. Thank you very much.